is The Opinions, a show that brings you a mix of voices from New York Times opinion. You've heard the news. Here's what to make of it.
I'm Lydia Polgreen, an opinion columnist for the New York Times.
And I'm Gessen, also an opinion columnist for the New York Times.
So, Trump and the GOP will have a governing trifecta in the new year. And amid the many policies that I think will hurt many Americans is a shift in the way the government and the courts see equal rights, particularly those for some of the country's smallest and most vulnerable minorities. Last week, the Supreme Court heard arguments on whether or not Tennessee could ban gender-affirming care for minors. And we won't know for sure until June, but there's already analysis that the court seems to be leaning toward upholding the state's ban. Masha, you were there in the courtroom. I wonder what it was like in the room.
I hadn't been to the Supreme Court since 2019. And 2019, I was there for the oral arguments in the Bostock case, which is the last time the court took up the topic of trans rights. And that was the amazing decision that Neil Gorsuch, of all people, wrote that ruled that trans people are covered by Title VII for the purposes of employment discrimination, which is the biggest judicial victory that trans people have ever had in this country. So, and I remember, getting an email from the Supreme Court press service before going to the hearing that outlined the dress code for men and women, and thinking, okay, well, what do I do? Do I wear a tie? I don't wear ties. but obviously I'm not wearing a skirt. Like, what do I do, right? And I ended up going in a suit and an open collar shirt. So this time, the press guidelines did not specify male and female dress codes. They just specified business attire. And I was definitely not the only trans people in the press room, which I think I may have been last time. And then there's this, I don't know if you've ever been to the Supreme Court, but as in many of those press situations where you're a group, suddenly you become like toddlers. You handed these cards with your seat number, and you're supposed to line up in order of your seat number, and then you're marched into the room, single file. But first, a staff member got up on a chair and said, "Does anybody need to go to the bathroom?"
Wow.
Which, is a loaded question. Because it's hard to go to the bathroom in a federal building. And then she proceeds to say that the men's room is next door to the press room, and the women's room is down the hall. And if that's not bad enough, another reporter raises her hand and says, where did non-binary people go? And the staff person was like, I swear to God, she'd never heard the word non-binary.
Wow.
And so, then everybody went to the press room, and as far as I know, nobody had an accident. But it was a reminder of just how tenuous our presence there is, and how recent this visibility is. Right? Like, this particular person, if I understood the dynamics correctly, she won't notice when non-binary people become invisible again, because to her, they never became visible.
Yeah. For people who haven't been following, can you just briefly summarize what this case is all about and why it matters?
So the Tennessee law bans all gender-affirming medication for minors. And 3 Tennessee adolescents and their families sued the state of Tennessee, and they argued that the law was unconstitutional on 2 grounds. One is that it violated the Equal Protection Clause by discriminating on the basis of sex or transgender status. And the other is that it violated due process by making decisions that rightfully belong with parents and the family and not with the state. So the Supreme Court agreed to hear the case, but only on equal protection grounds, not on due process grounds. So what to me is actually the most important part of the case, which is the actual care and who decides on care, that wasn't part of the case, right? It wasn't part of what we heard in the Supreme Court. There wasn't a single reference in the oral arguments to the actual 3 families.
So they were just there kind of as bystanders in a way of this process that was about something maybe more abstract than their actual lives.
It's weird because usually strategic litigation focuses on the human story, and it was totally sterilized and dehumanized, with the exception, I'd say, of one moment when Justice Ketanji Jackson said that she was reminded of Loving versus Virginia when the state was challenged on equal protection grounds, and the state was arguing that there was no discrimination, but also, she pointed out, was arguing that the science was on its side.
Well, let's come back to that because I think that that really kind of gets into the meat of what I think we should talk about this argument and this decision. But I first want to just kind of back up a little bit. The lives of transgender people and the affirming care that they seek out, this has become really central to our politics in a variety of ways. And that's interesting and striking because this is actually a pretty small group of people. But the politics around it seem to have proven in places that you've covered and places that I've covered to be just incredibly potent. So could you talk a little bit about that disjuncture? I mean, it's having this sort of weird clinical discussion about rights while there's been this kind of ferment and stirring up of animus around trans people.
Yeah, so, I've been thinking about it in several different ways. One, and it's almost a cliche, but I think it bears repeating, that budding autocrats, they go after minorities, they go after the most marginalized people, they go after people who are most vulnerable, but also, I think, they strategically focus on reversing social change that is most recent, that's easiest to reverse. And of course, in that sense, trans people, LGBTQ people more generally, but trans people in particular, are the perfect target.
Mm, mm.
There's a real built-in conflict between autocracy and expertise. And we really saw that conflict play out. And, we've seen it play out in legislatures all over the country. And we saw it play out in the Supreme Court. I mean, it's pretty amazing when dozens of professional medical associations file briefs with the court saying this is the standard of care. And I should say, obviously, as a queer person, and actually somebody who's written extensively in my career about medicine, I don't always think that standards of care are unassailable. But they should not be overruled by legislature or the courts. There are other places to litigate whether standards of care are correct. The media is one of them, but the courts are not. So what's incredible to me is that the justices seem to be unaware of this basic tension, like that they shouldn't be doing this. They should not be posing questions about medicine. They should not be ruling on questions of medicine. And they kept incredibly returning to questions of medicine, getting completely lost in the weeds because they don't know what they're talking about, which they shouldn't. They have other things to think about that they do understand. And yet they seem to think nothing about the problem of ruling in this space. And that to me is a symptom of just how far we've fallen.
Yeah. Well, it's interesting listening to the argument virtually. I was really struck by how often the justices, particularly on the conservative side, kept returning to this idea of the science being uncertain. There were frequent invocations of some of the changes that have taken place in Europe. I've written about them. You have as well. That have kind of pulled back, I guess is one way you could describe it, and have thrown questions about how sure are we that this care is effective, that it's safe, that it's this, that it's that. And there seemed to be, in an uncharacteristic way, a desire to bring in international expertise in a way that's quite unusual for conservative justices in the Supreme Court. But it did seem as though, and there was a particular moment, I think, when Justice Kavanaugh said something like, well, there's a group of people that you're claiming are harmed, meaning trans children, if they don't get this care. But there's also a group of children who would be harmed, children who maybe would regret having received this care, as if they were somehow equivalent groups of people. And there did seem to be this desire to sort of throw up their hands and say, well, someone's going to get hurt and we just need to leave it to the legislature to decide where to kind of weigh in on that.
Right. And Justice Kavanaugh said, there are risks on both sides, which again, does not seem to me to be a space that the Supreme Court should be venturing into. Right? It decided very narrowly on what questions it was going to consider. And yet during the hearing, it kept going well outside of that question of equal protection into questions of science. And you're right, yes, they kept invoking, I think it was particularly Justice Alito who kept invoking the Swedish and British revised policies on gender-affirming care. As I think you've pointed out, these are national healthcare systems. And what they're looking at are healthcare regulators. So what they're actually looking at as precedent is the debate that's happening inside the medical community where it belongs. And so medical authorities are introducing more stringent guidelines for the medical community, which is a world of difference from the legislature introducing guidelines for the medical community. And the fact that our justices don't seem to be able to know the difference is shocking.
Well, so let's come back to this question of the two separate arguments that were made and dwell for a moment on the one that the justices decided not to hear, which is the question of kind of who makes the decision. One of the conversations that's been happening around transgender rights, and you recently wrote a column about this, is about this idea, this connection between kind of bodily autonomy, choice, broadly speaking. I think advocates for abortion have made this, and advocates for trans rights have made this analogy between the need to be able to control your own body and make your own medical decisions, and linking trans rights and abortion rights together in that way. And I think you took the argument even a step further. But that argument about kind of who makes the decision, and in the context of trans rights, I think a kind of ideal argument was one where it was saying, hey, actually, parents should be in the driver's seat along with doctors making this decision. And the court decided not to hear that argument, which was striking to me. I'm listening to the argument. It seemed that they were basically saying, it seems like there's a lot of controversy here. We judges can't necessarily decide, but the right people to decide are not the medical experts, but the legislature.
Exactly.
And that they're the ones who could kind of parse through all the evidence and make these decisions.
Right. But let's backtrack for a second to the first part of your question, which is about how we even think about trans rights, right? And I think that one way to think about it is to think about bodily autonomy. But the way that I propose taking it further is that I think it's a lot of the fight is actually a pure reproductive rights fight. I'm not actually a huge fan of reframing the right to abortion as the right to choose. I think that calling things what they are is generally useful. And it is particularly useful when we think about the similarities between the right to abortion and the right to trans care. It was very clear during the Supreme Court hearing when the Tennessee Solicitor General was speaking. What's the ultimate harm? The ultimate harm is the loss of fertility. That's what they're really sort of positing as the reason to ban treatment, as the thing to avoid. It's not so much about regret. It's really about young people and their families who should not be allowed to decide whether they reproduce. And that, I think, is a useful frame because then we realize, oh, wait a second. These guys are really trying to decide who gets to reproduce and who should be reproducing all the time. They are both in their legislative efforts regulating reproduction, and then their politics constantly raising reproduction as sort of the ultimate goal or the ultimate space of regulation.
Yeah. Well, and so, I mean, it is striking that sort of all of those questions were kind of put to the side of, kind of who decides, and everything was in the argument was invested in this question of equal protection. So let's dig into that a little bit. One of the most sort of poignant moments for me in the hearing was when Ketanji Brown Jackson invoked the Loving case. And, Loving v. Virginia was a case in which the Supreme Court decided that laws against interracial marriage were unconstitutional. And, I think that what she saw coming in the kinds of arguments that were being advanced in favor of this not being sex discrimination, I think she feared were arguments about equal protection that could really eat at the foundations of some of our basic ideas about what equal protection is. And, the interpretation of the 14th Amendment that comes out of, say, something like Brown v. the Board of Education, that separate can't really be equal. And so I think I sensed, and I'd be curious how it felt in the room, I sensed a real kind of certainly concern about, kind of where this kind of reasoning leads you, because the government of Virginia tried to argue that there was a scientific basis, right? That racial differences were actually meaningful differences of different types of human beings.
I also found that moment, it felt profound. And it felt profound because it was a moment of a kind of like what the Supreme Court should be, what the Supreme Court has been on occasion, which is a place of a kind of real moral searching and aspiration. And it really threw into relief what the rest of the hearing felt like.
Yeah, I think that one of the things that feels like it kind of gets lost in all of this is the actual, like, what's really at stake here, right? I mean, we're talking about, young people and their access to treatments that will help them feel more at home in their own bodies, make them able to perhaps delay puberty to give them time to think about what they really want for themselves and for their future. But I think there was also a sense, from the questions that if this law is constitutional, there's not much keeping transition for adults safe. So could you play that out a little bit?
Sure. I mean, again, I think that the fact that the court decided to hear this case communicates that it is okay for a legislative body or any other kind of government authority to make decisions about people's medical treatment. But if we leave it unquestioned that the government can make decisions and can overrule the will of the doctors and the family or the patient, then there's absolutely no reason for state legislatures or the federal government not to ban gender-affirming treatment altogether. It's happened elsewhere. It happened in Russia, where I'm from. Why wouldn't it happen here?
Well, Masha, I really appreciate you taking the time to talk about this. And as always, great to hear your perspectives.
It's always good to talk to you, and thank you for guiding this conversation.
If you like this show, follow it on Spotify, Apple, or wherever you get your podcasts. This show is produced by Derek Arthur, Sophia Alvarez-Boyd, Vishaka Durba, Phoebe Lett, Christina Samuelewski, and Jillian Weinberger. It's edited by Kari Pitkin, Allison Bruzek, and Annie Rose Strasser. Engineering, mixing, and original music by Isaac Jones, Sonia Herrero, Pat McCusker, Carol Saburo, and Afim Shapiro. Additional music by Amin Sahota. The fact-check team is Kate Sinclair, Mary Marge Locker, and Michelle Harris. Audience strategy by Shannon Busta, Christina Samuelewski, and Adrian Rivera. The executive producer of Times Opinion Audio is Annie Rose Strasser.